Well, joining us now in our studios is Piet Oliver. He's a legal researcher at the Helen Suzman Foundation. They've filed that affidavit to the courts to have the charges against Pravin Gordhan struck down. A very good morning to you, Piet. Before we get into that side of the story, what do you make of the latest SARS revelations here?
Look, it's very worrying that a SARS official was held hostage or kidnapped or held in his office against his will. And then members of the Hawks, without a warrant, without arresting him, were demanding a document. And in addition, it seemed like Tomoyane's personal bodyguard was also involved. And this is just the kind of lawlessness and thuggery that should worry all South Africans.
Let's get on to the Helen Suzman Foundation, your involvement with this Pravin Gordhan matter. Why are you guys getting involved in this?
Well, because it seems like our institutions are being misused for political purposes. So what we see with the charges against the minister is that on the law, they're bad, and on any plausible version of the facts, they're even worse. And what we're doing is we're applying to a court to get those charges set aside.
Let's look at the merits of it. It's all surrounding an early retirement and the whole early retirement with a contract renewal there. I listened to an interview that you did with regards to a memorandum and annexures. Just explain to us where you think this is all unfolding.
Right, so the minister is facing 2 charges of fraud. He's facing 1 charge of theft, and it's in relation to the early retirement of Mr. Pillay and then his subsequent re-employment as Deputy Commissioner. Now, in order for him to be found guilty even remotely of fraud or theft, it has to be shown that the early retirement was unlawful. Now, what the memoranda show, and the memoranda form part of our initial application and part of our supplementary affidavit, they show that this retirement and reappointment was completely legal, and it's happened many, many times before, which begs the question as to why the Hawks are only paying attention to this now.
Just because it's happened before, does it make it legal? I mean, just by the fact that it's happened before, is it illegal to give someone early retirement and then offer them a new contract?
No, look, that's a good question. But regardless of whether or not it had happened many, many times before, it's perfectly legal. If you look at all of the relevant pension laws, they say that a government employee may retire early and that in certain circumstances, and this is one of those circumstances, the employer is required to pay the early retirement penalty. On the issue of re-employment, SARS is a government body. It is, of course, allowed to employ whoever it wants to fill important positions, which is exactly what it did here.
I guess what's on everyone's lips is that there's political motives here. I mean, you look at Ivan Pillay and Oupa Magashule, they made representations to the NPA to have it relooked at, but the finance minister didn't. Why, in your view, didn't he?
Well, the finance minister made it quite clear why he didn't. It's because he didn't believe that he would get a fair hearing from Shaun Abrahams. And there are good reasons to think that he wouldn't. We see that Mr. Abrahams met with President Zuma and many other people in the security cluster the day before the charges were announced. And we've never really gotten a good explanation as to why he met with those officials. And in addition, Mr. Abrahams had a theatrical press conference when the charges were announced. He spent half the time talking about the so-called SARS rogue unit when the charges had nothing to do with the rogue unit. And then afterwards, we see that these charges are completely trumped up and without basis in law. So if I were the finance minister, I would also have good reason to think that I wouldn't get a fair hearing from Mr. Abrahams.
Right, Piet, so 2nd of November, that's next week, the finance minister will be appearing in court. In terms of timings of your appeal, how does it work time-wise and legally-wise?
Sure. So what we have here is we have 2 parallel legal processes. There's the criminal process against the minister, and then we have our separate process, which is before a different judge in the High Court, to get the charges against the minister set aside. Now, the minister has his appearance in the criminal process on the 2nd. We hope to get the answering affidavit from Mr. Abrahams before then, but we're hoping to get a court date on the 8th. Now, the minister's first appearance on the 2nd, it's unlikely that anything really will happen at that first appearance. Nothing usually does. He'll get the charge read to him. He might make a pleading. He might get to see the docket. But the trial definitely won't happen on the 2nd. So we're predicting that our action or our application will be heard well before the trial substantively starts against the minister, and we're also confident that these charges will be set aside before the trial against the minister begins.
Sorry, just to excuse my ignorance in terms of legalese here, but at some point the two cases will have to join if you're looking to have these set aside.
No, they're two separate processes. So you have the criminal matter against the minister, and that starts on the 2nd. Our matter is a parallel matter to the High Court to get the decision to charge the minister set aside. Now, if the decision to charge the minister is set aside, then that criminal process falls away. But ours is a separate process to get the criminal process set aside.
Great. I get it. I understand that. Great. So, Piet, thanks so much for chatting to us this morning. That's Piet Oliver there from the Helen Suzman Foundation, and they have supplied those affidavits to have the charges against the finance minister struck down.